Welcome to the Insurance Agents and Brokers Podcast.
Hello, and welcome to the audio version of Coverage Corner. Coverage Corner is a monthly column in IA&B's primary agent magazine. The February 2026 column is entitled Insuring Teenagers and Their Autos by Bill Wilson. Everyone knows how expensive it can be to add a teenager or other resident dependent to their parents' auto policy, especially policies with high liability limits and perhaps an umbrella policy. Over the past 50-plus years, I've heard from agents whose customers have been counseled by attorneys or financial planners to consider insuring resident teenagers on their own auto policies, often at minimum limits that reflect the very limited assets owned by the child. There are several potential problems with this approach. First, just because a teenager has limited assets today doesn't mean they won't have substantial assets in the future that could be attached in a lawsuit. I'm personally aware of 2 instances involving motor vehicle deaths where a teenager acquired a large inheritance at age 21 that was forfeited, and a medical school student had wages garnished for up to 20 years. Second, just because the teenager or dependent doesn't have assets doesn't mean the parents don't have assets. Many states have, with or without damages caps, some sort of parental liability laws. Other states may, via case law, apply a common law family purpose doctrine to potentially create liability for parents. Even without such laws, parental liability may be found on the basis of vicarious liability. For example, the law of agency, negligent entrustment or supervision, dangerous instrumentality doctrines, etc. There are many ways for a creative trial lawyer to proceed against parents. In addition to these vicarious liability-based laws, a parent can also have direct liability for an accident when a resident child is operating an auto. For example, in one case I was consulted on, a teenager ran a stop sign and T-boned a compact car. The impact killed the pregnant driver, and her 14-year-old daughter was rendered a paraplegic to be cared for by her now widowed father. It was alleged that the teen, in addition to speeding and texting, lost control of the car due to a wobbly spare tire that his father had changed that morning. If true, that created a direct liability for the parent in addition to any vicarious liability. This leads us to a third potential problem if a low limits policy had been issued to a resident teenager, or potentially any other resident family member. Needless to say, in the event of a serious accident for which the teenager was legally liable, low limits will not be adequate. Aside from garnishing the potential future earnings or assets of the teenager, a liability suit against the parents is a virtual certainty. And that's where the insurance problem becomes even worse. Let's first consider the teen's policy, presuming a current ISO personal auto policy, or PAP. There are 4 categories of insureds under the ISO PAP. The teen's parents probably fit the first one and certainly fit this second category. For your covered auto, any person or organization, but only with respect to legal responsibility for acts or omissions of a person for whom coverage is afforded under this part. The problem is the low limits of the teen's policy. But the upside is that defense is provided without limit, and that cost can be substantial. But let's presume the parents have their own auto policy, and perhaps a sizable excess or umbrella policy. Wouldn't they be covered under their own policies? Unfortunately, under the ISO PAP, there is an exclusion for the ownership, maintenance, or use of any vehicle other than your covered auto, which is owned by any family member or furnished or available for the regular use of any family member. There is an exception to the exclusion, but it applies only while you are maintaining or occupying such a vehicle. In other words, the parents likely have no coverage whatsoever under their own policy. They may or may not have coverage under an umbrella policy, but given that there's no industry standard for excess or umbrella coverage, one would have to read such a policy carefully to know if there was coverage. Finally, there could be a fourth issue. Even if the teenager's auto policy was adequate to protect the child and his or her parents, if the reason for placing the teenager on his or her own policy was to limit the amount an injured party could get from the responsible family member, what message do the parents send to the child? Do we not have an ethical, moral, or social responsibility to be responsible for compensating others for our negligence rather than attempting to escape liability on a technicality? I believe we do, and that's why, even though our son is emancipated and living on his own, I have convinced him of his responsibility to carry reasonably adequate policy limits and assured him that, if he is ever unable to financially afford such coverage, I'll pay for it. Written by Bill Wilson, CPCU, ARM, AIM, AAM, is the founder and CEO of InsuranceCommentary.com and the author of 6 books, including the Amazon 4.8-star When Words Collide, Resolving Insurance Coverage and Claims Disputes, which Book Authority ranks as the #1 insurance book of all time. He can be reached at bill@insurancecommentary.com. Thank you for listening.
Insurance Agents and Brokers is the premier resource and champion for independent insurance agencies in Pennsylvania, Maryland, and Delaware. For more information, visit iabforme.com.